How do letters testamentary apply to intestacy? Imagine trying to settle an estate without a will, who would step in to handle everything. That's where understanding how letters testamentary and intestacy connect becomes important. When someone passes away with a valid will, the court issues letters testamentary to the person named as the executor. This document gives them the legal power to manage the estate, pay debts, and distribute assets as the will directs. But what happens if there is no will? That's called dying intestate. In that case, the court doesn't issue letters testamentary because there's no named executor. Instead, it appoints an administrator through a process called probate. The court then issues letters of administration to this person, giving them similar authority to handle the estate. Both letters testamentary and letters of administration serve as proof that the person managing the estate has legal authority. They are necessary to access bank accounts, sell property, or pay taxes. The main difference is that letters testamentary are only issued when there is a valid will, and the named executor acts according to the deceased wishes. When there is no will, the court's appointed administrator with letters of administration manages the estate based on state laws of intestacy. These laws determine who inherits assets, usually close family members like spouses, children, or parents. From an estate planning perspective, knowing whether a person died with or without a will affects how the estate is handled. If a will exists, the executor with letters testamentary can quickly start the process. Without a will, the court's appointed administrator with letters of administration must follow state rules to distribute assets fairly. Both roles carry fiduciary duties, meaning they must act honestly and in the best interest of the estate and heirs. So, in simple terms, letters testamentary apply only when there is a will, giving the named executor authority. When there is no will, letters of administration step in, appointed by the court, to oversee the estate. Understanding this difference helps families and legal professionals navigate estate administration smoothly, whether or not a will is involved.